respected speaker, dignitaries on and off the dais, dear colleagues, SI cadets of 31st B, C, and D batch, and women police recruits, a warm good morning to one and all present here. Today we are privileged to have an interactive session with the Honorable Judge of Kerala High Court, Justice Amit Rawal. On this gracious occasion, may I now invite our respected director, Shri K. Sethuraman IPS, to extend a warm welcome and introduce the speaker.
Morning, sir.
Morning.
Morning to all. It's a great honor and blessing for me to introduce His Lordship, Justice Amit Rawal. He was born on 21st September 1963. He is a native of Chandigarh, graduated from DAV College, Chandigarh in the year 1983, and achieved his degree in law from Punjab University in the year 1986. Enrolled as an advocate with Bar Council of Punjab and Haryana on 7th September 1986. His Lordship represented before diverse courts and regulatory bodies and dealt with cases in different branches of law. His Lordship prominently dealt with matters pertaining to civil matters involving matrimonial disputes, winding up amalgamation matters, writ involving wires of various acts. Gained significant experience across the legal spectrum and had extensive practical knowledge in all legal domains. His Lordship represented the Bar Council of Punjab and Haryana before the High Court, designated as a senior advocate by the Punjab and Haryana High Court on 8th May 2012. Served as the Additional Advocate General in the Office of the Advocate General Punjab, elevated as Additional Judge of Punjab and Haryana High Court on 25th September 2014, and confirmed as the Permanent Judge of Punjab and Haryana High Court with effect from 23/5/2016. His Lordship was sworn in as the Judge of High Court of Kerala on 12th November 2019. So this is first in the series of interaction with honorable judges, and it is in collaboration with the Center for Public Policy and Legal Research. Advocate Sanjay is also here, and Advocate Jasmine is also here with us, and I also welcome them. And the Center for Public Policy and Legal Research is undertaking legal education throughout Kerala by conducting various seminars, symposiums, as well as directly interacting with various stakeholders in the criminal justice system. So it is a honor for me to welcome both of them. And it is in their collaboration we are conducting a series of lectures. And this is the first lecture, inaugurated lecture by Honorable Justice. So I wholeheartedly welcome His Lordship Amit Rawal to this function. Please, sir. Thanks so much.
A very good morning to all of you. And thank you, Sethuramji, for introducing me. But one thing you missed out. Is my voice laudable? Can you acknowledge, please?
Yes, sir. Yes, sir.
Okay. One thing you missed out in my introduction, though I'm from Punjab and Haryana, but so far I have been working in Kerala for 5 years, but I've not been able to learn Malayalam. It's a very difficult language. So I welcome all the new entrants into the police post, which is a very coveted post and responsible post. The administration of the state depends upon the law and order situation, which is in the hands of the state, government machinery, and as well as, of course, the police. The number of police officials vis-a-vis the population concerned, of course, are far less than they are required to be. But still, I must applaud that they are doing all up to their best capability and have been discharging duties at the cost of their personal life, family, and children. See, this role of a police official is very, very important, particularly at a stage when you have just entered this service. Our Indian Constitution regarded as the foremost responsibility of the state there have been a very important judicial pronouncements on very three, four points, as you would recollect, and you must have watched in the movies also, that earlier the person used to be handcuffed, and the duration in the jail was also for an innumerable period without any timeline or something like that. So there are five judgments on this point, which should you know and read it while studying. One is Hussain Ara Khatun versus Home Secretary State of Bihar, where it was laid down that in case you detain the under-tiles in jail for a longer duration than required, than prescribed a penalty, it is a violation of Article 21. Article 21 has a pivotal role in protecting the life and liberty of the citizens, and the role of the police is to send a message that they are not misusing their power as and when they receive the complaint without any favor or partiality. And up to their dedication, they have to discharge duty, as we also have taken an oath to discharge the duty, to abide by the laws and whatever is written in the Constitution. The another judgment where this system of handcuffing was done away with is Prem Shankar Shukla versus Delhi administration, where it has been said that the accused should not be, it would be a total inhuman and unreasonable in case the accused is in the first instance handcuffed. Yes, there are certain very uh, hardcore criminals or history cheaters who have who have a long history of committing the crimes. There are certain examples and instances where it is inevitable that they have to be either tied with a rope, or if not possible, last stage is the handcuffing. Now, another landmark judgment given on is that as whenever any prisoner is incarcerated in a jail and he performs the duty work assigned to him, he must get wages. That is in Prakash Singh versus Union of India. And then freedom of movement and liberty to the prisoners in the jail was also noted by the court in a judgment called SP Anand versus Madhya Pradesh. Now you would recollect that before this new act came into force, these three acts came into force. That is the Bharatiya Nyaya Sanhita 2023. The previous was Indian Penal Code. Bharatiya Nagrik Suraksha Sanhita BNSS, which was earlier a Criminal Procedure Code, and another one is Bharatiya Sakshya Adhinayam 2023, which is the Indian Evidence Act. Before these acts came into force from 1st of July 2023, 2024, sorry. Now, it has raised a very serious concern to strike a balance, because as far as present situation is concerned, the landmark judgments with regard to the arresting of the persons in respect of the acquisitions of the commission of offences less than 7 years of service or 7 years of punishment sentence, or with regard to the procedure in lodging the complaint and the period for seeking the custody. This is a landmark judgment of the Supreme Court on this point, when this new act had not come into force, is a Lalita Kumari. This judgment is a Magna Carta. It is a Bible for you to cram and read it. You will encounter a lot of things like this initial stage when the complaint is given and lodged, and you have to take a call on that. That is called Lalita Kumari versus Government of Uttar Pradesh, 2014, Volume 2, Supreme Court Cases, page 1. In Lalita Kumari, What was the necessity of coming out with the direction in the cases? As you must have heard, there have been a lot of complaints regarding the matrimonial disputes amongst the spouses, which leads to registration of an FIR under 498A of the Indian Penal Code, commercial offences, complaints against the doctor's medical negligence, corruption cases, or where is there is a delay in initiating the criminal prosecution. For example, 3 months of delay in reporting the matter until unless there were certain mitigating circumstances. So in these three categories, it was held that before and if at any point of time when a person comes for registration of FIR, one should not be arrested straight away. If the power of arrest is a discretionary, and you have to call the person to join the investigation by issuing a notice under section 41 and 41A of the old act, that is the CRPC, and new section is section 35 of the BNSS act. The whole purpose to comply with these provisions, which was basically had been in the CRPC incorporated little later, was not being followed by the police across the country. I'm not talking about the particular state. And that was the need for the Supreme Court when they had been coming across number of cases where on registration of the FIR, even of in respect of the offences which I have narrated above, persons were being arrested and the courts were flooded with the bail applications, either anticipatory and when arrested, regular bail applications. So the 41A CRPC, which is now 35 in BSc, was incorporated in 2009 by an amendment of Act number 5 of 2009, and then of course by Act of 41 of 2010. These sections say that it is basically preventing the police from indulging into the abuse of the powers. See, there are police officers are also human beings. Some people have tendency to work within the four corners of the law, and some people sometimes exceed their jurisdiction. So, in order to bring succor and strike a balance, this section was incorporated, and it was said that in all cases the police officer, if it wants to arrest a person, is not required to arrest a person, has to send a notice under section 41A that you have been accused in a complaint and there is a credible information has been received, or there is a reasonable suspicion that he has committed a cognizable offense. Earlier in the 2009 amendment, which I was referring about, the word was may, but in 2000 the word has come shall. So earlier the power of the police officer was he may send the notice or may not send the notice, but now it is mandatory, he has to send the notice. The same provision is incorporated in section 35 of the BNSS Act. And while issuing the notice, you have to record the reasons in the daily diary, in the book maintained by in the police station, and it should have a serial number and the date also. There had been cases where notices were sent, but the police people did not have the record of that, and court had to encounter such type of cases also. So then Delhi High Court came out with a judgment called Rakesh Kumar versus Vijayante Arya, DCP and none others, where it has been clearly laid down in the, I will quote, that it is not only the accused who suffers the humiliation and indignity of being arrested, rather the ordeal effects of reputation of his whole family. He will not be able to give an explanation to his neighbors or those who have seen him being arrested or embarrassment. So the steps were taken to that he will not be arrested in respect of offences referred to in the notice unless for the reasons recorded, the police officer is of the opinion that he has to be arrested. Then these guidelines, another judgment came on. You see, when you pass the judgments, we also come across certain cases, and whenever different kind of a case comes, we encounter that this kind of a situation was not envisaged in the already held case law. So it keep on adding the circumstances. So the latest judgment thereafter was a judgment called Arnesh Kumar versus State of Bihar, 2014, Volume 8, SCC, page 273, whereby all state governments have been directed to instruct the police officers not to automatically arrest when a case under Section 498A, 498A, 4 of the Dowry Prohibition Act has been registered or where the punishment is less than 7 years. They have been directed to provide with a checklist containing the specified clauses mentioned in the erstwhile section of 41B, which is also incorporated in section 35. This checklist will be forwarded and furnish the reasons to the concerned magistrate for in case you actually require the detention and arrest. Before that, you cannot. You have to take the permission of the magistrate. It is the only magistrate which will authorize you that yes, though there is a case law and there is a provision in the act, but still it is a inevitable or it is a high time or circumstances warrant that the person has to be arrested. Otherwise, he will indulge into harassing the witnesses or the complainant, and ultimately, no purpose would be achieved. Now, this decision not to arrest the accused has to be forwarded to the accused within 2 weeks from the date of the institution of the case with a copy of the magistrate in case the FIR is registered. Now, question rises whether the accused has appeared or not appeared was also a point of consideration before the courts. Therefore, it was laid down that there will be a record where the police officer will give an acknowledgement to the accused that he has appeared before you, so that the police officer will not be able to tell a lie to the court or vice versa, that the accused that I had appeared and I was not given the acknowledgement. So on this, there were certain ambiguities on this point. Then another judgment came, that is of Delhi High Court, that is Amandeep Singh Johar versus State of NCT of Delhi and others, where exhaustive set of guidelines have been laid for compliance of the provisions of Section 41A of the CRPC. Erstwhile, I would not be repeating again. When I am referring to 41, you mean to say it will be 35 in the new act. Now, what are those guidelines? You must register in your mind or make a short point, and thereafter you can read it. And after all, whenever you keep on reading it, will be automatically, earlier you need to cram it, automatically it will imbibed and it have an indelible mark in your memory also. That whenever an accused receives a notice under Section 41A of the Act, appearing before the concerned officer for investigation, he will request the IO to give the acknowledgement. Accused will be directed to appear at a place in the notice mentioned by the police officer at a police station, and he'll be have a liberty to get an acknowledgement receipt attested by an independent witness. And suppose there is no availability of the independent witnesses, then it has to be attested by a investigating officer by himself, because sometimes he may bring an independent witness or there may be some other person in the police station, of course, then you can avail this, comply with this direction. But if it is not so, the IO has to give the acknowledgement. Now, there has to be a duly indexed booklet to be maintained in the police station containing the serial number, the number of notices in duplicate or in carbon copy format, or it can be in the computer generated also, in where you can have the serial number so that it cannot be subsequently generated. And notice will have to contain the necessary details, that is the serial number, case number, date and time of the appearances in the event of the failure of complying of the acknowledgement slip. The investigating officer has also been directed to follow that the original is served on the accused or a suspect and a carbon copy is retained by him to be shown to the concerned magistrate as and when required or directed. After the booklets are complete, they have to be submitted to the SHO of the police station, who shall retain it till the final completion of the challan in the erstwhile in the section 173(2) of the CRPC. And then the police department of all the states have been directed to prepare the rules for destruction of the record. Now, a very vital and important question comes regarding the FIR and the preliminary inquiry. Section 173(3) of the BNSS Act is not in tandem with the Lalita Kumari's judgment. There are critical areas of where there is a conflict between 173(3) and Lalita Kumari's judgment, which will definitely cause certain delays. And what are those? I will be enumerating you step by step. There are two landmark judgments. Of course, these judgments are pertaining to political persons who had been chief ministers of Haryana and Punjab. Earlier, Bhajan Lal and Prakash Singh Badal. So, whenever any information is received regarding or a complaint is received by the police officer, he has to register an FIR and hold a preliminary inquiry, which though does not exist in the mandate of section 154 of the erstwhile CRPC. Whereas in the 173(3) BNSS Act, there is a little inconsistency. It gives a discretion to the police officer in respect of an offense, serious offenses which require immediate FIR registration of even lesser severe offenses, that is punishable up to 2 years or by 3 years to 7 years. Now, under the old act, police could take the custody during the first 15 days of the investigation. And after that, the accused is either placed in a judicial custody or granted bail. But under the new BNSS regime, police can request custody in parts. For example, I will tell you. Police can request for a 4-day custody, for which the accused can be granted bail. Thereafter came for 11 days. And then later on, another for 4 days custody. So ultimately, this period stretches to 40 to 60 days, which is not in tandem with the judgment in Lalita Kumari's and various other judgments, depending upon the severity of the offenses. So, regarding the custody, a landmark judgment came on this point, that is DK Basu versus State of West Bengal, 1997. Volume 1 SCC page 416, that why this custody should be limited and why it should not be extended, because in order to rule out the not physical harassment and but the mental agony. If a person is confined in the 4 walls of the police station or in the prisons, it will have a very devastating effect on his health and of course on his family. Now, I would be commenting upon the criminal justice system in India and challenges in policing. This is a landmark a case regarding Chandra Kumar, where a contempt petition was filed against an investigating officer. And what was the contempt being alleged of? That he had not followed the judgment of Agnesh Kumar versus State of Bihar and had arrested the persons where the offense was involving was less than 7 years. He was sentenced to go a simple imprisonment of 14 days. In that case, the IO served a notice on the accused as per the provisions of section 14(1)(a), but he deliberately recorded in the GD that accused denied to accept the terms and conditions given in the notice. There was some kind of a communal color was also given, but the conclusion the court had given was that the arrest was done by bypassing the guidelines laid down in the Agnesh Kumar. So Agnesh Kumar is a Magna Carta now, because earlier the police had at the rims and fences, depending upon the different state, the mindset, the directions, the severity of the crime, even if it is less than 7 years, but according to him, it is very severe and immediate arrest is required, cannot be avoided. Keeping in view that background, that landmark judgment of Agnesh Kumar had come. Now, there's another matter where similar guidelines or similar guidelines laid down in the Agnesh Kumar. Another police officer was also sentenced to a 1-day imprisonment for arresting a person by defying the Agnesh Kumar's guidelines. You must read those judgments because at some stage of your career, it may work as a deterrence to you. That is called Rakesh Kumar versus Vijanta Arya, DCP and others. Now comes a point, what would be the impact of not arresting the accused? As we have discussed that it is obligatory upon the IO to send a notice to the accused whenever an FIR is registered or a complaint is given, calling upon the accused in respect of those offences which I have already mentioned to appear. So, the mechanical interpretation of the provisions sometimes will not serve the purpose of guaranteeing the safety by diminishing the fear instilled in the mind of the victims and the witnesses. So, whenever a preliminary inquiry is held, excuse me, and you find that yes, this person requires to be arrested, then you have to comply under the erstwhile provisions of section 41 and 35 of the BNSS. Make an application to the magistrate, give the reasons, satisfy the conscience of the court why the arrest is required. What is the need of arresting? Of course, you will be. Now, apart from what I have already spoken of, there are other certain provisions which have to be taken into consideration. You must, there are certain already serving police officers having a vast experience, and the new entrants would of course encounter this. It has become a tendency amongst the litigants to convert the civil dispute into a criminal dispute. For example, I will give you a hypothetical situation. A and B, A is a seller and B is a purchaser. They have entered into an agreement to sell and agreed to purchase a parcel of land, house, or whatever, with certain terms and conditions that you have to comply with this and on payment of some earnest money. And if the seller required to obtain certain NOCs from concerned authorities or have a clear title, or it was under a loan to clear the rule and obtain the no liability certificate, complies with those terms and conditions, then a date is fixed for execution and registration of the sale deed. Now, there is a separate code, separate act, which governs the resolution of a dispute among such litigants. That is called a special relief act. Now, it has been seen by the courts long time back in 1999 or in 1989, I believe, 1999, that people, instead of going to the civil court and avoid payment of the court fees regarding the value of the property which has been agreed to be sold for a particular price, lodges an FIR to the police station. The Supreme Court has said no. When you have an independent remedy, you have to avail that remedy. Now there is a caveat in this. FIR in certain cases can be registered, which can be those circumstances where on a reasonable inquiry, prima facie the purchaser, while entering or before entering into the agreement to sell, finds, yes, the seller has the ownership, but subsequently acquires on inspection of the record or some other material that he had already sold the property, created third-party rights, or the title is under defect, he is already facing a litigation, then of course it's a case of a cheating and a fraud, and FIR in such circumstances can be registered. There is no bar to that, because law is both criminal and civil proceedings can go side by side. So only in exceptional circumstances, FIR in such disputes can be registered. For example, now landlord and tenant. Tenant is occupying and paying the rent to the landlord. Suppose the tenant stops paying the rent. Landlord cannot go to the police station and ask you, please ask him to pay the rent. He has a remedy under the Rent Control Act. Go there and file a case and seek the ejectment, as there is one of a ground of ejectment. And in case they indulge into breach of peace, then there is a provision of 107, 151 of the CRPC, breach of peace. The proceedings can be initiated, and which is triable by the or entertained by the concerned SDM, as executive SDM. Now there is another fine distinction and a fine, I would say, a thread between two kinds of matters which have a trapping of a civil dispute and as well as a criminal dispute. I have already given you two examples in respect of a landlord tenant and a purchaser and a seller. There is another field. There is a will. Now, a will is registered by a person who is no more in this world, and it becomes operative only when a person is dead. During lifetime, he can keep on changing the will whatever he wants to. Now, there have been cases and tendencies amongst the siblings or the beneficiaries of the will or the successor in interest of the deceased to know that their forefather or their father or the executor of the will had acted in a partial manner, given more share to one of the beneficiaries and lesser to them. And there are circumstances where, on finding a empty paper bearing a signature of the deceased, or by fabricating the signature of the deceased, creates another will. Now, in such circumstances, there is a dispute. Property cannot be transferred in the name of beneficiary of the will, because one party is saying this will is fraud, is an outcome of fraud, and or the testator was under the influence, and after the fear and caution he had executed the will. There had been sometime a situation where, instead of availing the remedy in getting a nod of the will, by a declaration in a civil court, person goes to the police station and lodges an FIR. Now, the police is not an expert body to put a stamp that which will is correct, or whether if there are two wills, which is will correct, or if there is one will, it is correct. It is the duty of the court to decide, subject to the evidence to be led in accordance with the law already available, like Indian Evidence Act, and if the parties are Hindus, by Hindu Succession Act, and if they are not, then Indian Succession Act. There are certain parameters which are required for execution. Of course, that is the domain of the civil court. Civil court has the power to declare it. Now, once the civil court ultimately decides, yes, this will is fraud, is a forged and a fabricated one, and or has been obtained by practicing fraud, there are two situations comes. The same very magistrate can direct the police under the erstwhile provisions of the CRPC 195 to lodge an FIR, or the person who was disputing the will has a cause of action to go to the police and register an FIR that that person had indulging into a fabrication and forgery. But the judgment of the civil court will have only a persuasive value in case ultimately the challan is filed and the matter is referred to the judicial magistrate. To go into, it has to depend upon an independent evidence to be led in a criminal court to actually form an opinion that fraud and representatives, because that finding of the civil court will have only a persuasive value. It will not be binding that cut, paste, copy, and the person should be punished and then sentenced to undergo a sentence. So these are the situations which you will encounter in your day-to-day working, and there will be many other matters which you would find that a person find it very easy to come to you and file a complaint and get his grievance redressal, because of the late, the tendency and the pressure on the civil court has led to a series of complaints registered with the police more than expected. Not only in my part where I come from, probably I've had a discussion with Sethu Ramji, and I was told that this tendency has also crept in the state of Kerala. So it is a very intricate question. It is your call to see whether it's a fit case for registration of the FIR. Ultimately, you register an FIR and you hold an investigation, and in investigation, you come out that there is no material, then you put a closure report. Let the complainant file a protest report and prove it before the court. But if case you collect the evidence and find, yes, some cognizable offense has been committed prima facie, then you can file a report, and then prosecution will prove because the prosecution will also prove on the material you have collected in your investigation. So your investigation has to be very meticulous, not for the sake of satisfaction of the accused or your duty that I have collected and filed it. Ultimately, in case there is no material, the accused would have a benefit of doubt and get it acquitted. Now, there is another aspect where you will also encounter that many complaints are being registered or submitted by some perpetrators, which is not based upon any truthfulness. It's on the falsehood. So what action you are required to take against that person? In ultimately in investigation you find you have a power, even the court has also the power under the erstwhile provisions of 182 CRPC. There's already a table, old act and new act. You can always get compared, because I am still had a memory of the old provisions of the act. It will take some time for me to remember the new act, because of over a period of time and practice, you will come to know the new provisions. For lodging an FIR against the person who has been found to be not truthful in making a complaint and it was a false complaint and can be prosecuted. So I believe in this shortest possible time, I could share my views with you, though it's not a lecture or a verse of enlightenment. You will gain over an experience of time, and I hope it will really help you in your upheaval tasks which you will encounter in day-to-day life. Thank you very much. Anybody has any question to ask?
Your Lordship, thank you for a truly insightful and thought-provoking session. With your permission, the floor is open to questions. We now invite Advocate Jasmine, Executive Member for the Center for Public Policy and Legal Research, to extend the vote of thanks.
Respected dignitaries, esteemed guests, and dear participants, it is indeed a great honor for me to deliver the vote of thanks for today's enlightening session on criminal justice system in India, challenges in policing, jointly organized by the Kerala Police Academy and the Center for Public Policy and Legal Research, Cochin, an NGO in the forefront for organizing various activities related to law. First and foremost, I extend my heartfelt gratitude to Honorable Mr. Justice Amit Rawal for gracing this occasion with his presence and inaugurating this session. Your insights and perspectives have added immense value to our discussions. His Lordship shared his expertise and experiences, shedding light on the complexities of our criminal justice system and the evolving role of law enforcement with the latest criminal laws with various judgments, including Lalita Kumari and Arnesh Kumar, coupled with the landmark judgments of D.K. Basu case. A special thanks to IG Sethu Raman sir for his warm and inspiring welcome address. Your words have set the perfect tone for this session, emphasizing the importance of addressing the challenges in modern policing. A big thank you to the Kerala Police Academy and the Center for Public Policy and Legal Research Cochin, especially our Secretary Advocate T. Sanjay for their initiative in organizing this session. Your dedication to legal research and policy making is commendable, and such collaborations pave the way for meaningful reforms. To all participants, your engagement and enthusiasm have made this session truly interactive and enriching. Your presence and keen interest reaffirm the relevance of today's discussion. Lastly, I extend my gratitude to the organizing team, volunteers, and technical support staff who have worked tirelessly behind the scenes to ensure the seamlessly execution of this event. Once again, thank you all for your time, efforts, and valuable contributions. Let us to continue work towards a stronger and more effective criminal justice system in India. Thank you one and all. Jai Hind.